SJC-11932 and 11794, Commonwealth versus Monteiro and Commonwealth versus DePina.
Good morning, Your Honors.
Wait,
I-
Ms. Capiccio, wait.
Sorry. Jumping in too soon.
Jumping the gun, restrain your enthusiasm? Okay, now you may release your enthusiasm.
Thank you, Your Honors. Good morning, Your Honors. My name is Rosemary Capiccio, and I represent Esau DePina. There are two issues that I'd like to discuss with the court today. The first issue is the inappropriate use of grand jury minutes substantively from Ms. De Silva, and the second one is the erroneous immunity instruction. Now, with respect to the first issue, Ms. De Silva's grand jury testimony. This case was essentially a case where the Commonwealth has conceded that they needed Ms. De Silva's testimony in order to convict my client, that they could not convict my client without it. In this particular case, Ms. De Silva had a hearing prior to trial where she indicated that she had been threatened by the police department and coerced into making a certain statement. And the statement particularly was her knowledge of either or both of the defendants having a gun that looked like a police officer's weapon shortly before this crime, the weekend before when they were at the hotel room to celebrate her birthday. That statement was, at least according to her, was a false statement. That was coerced from her by the police, who told her essentially that she would be charged with the crime if she didn't put a gun in either or both of the defendants' hands. Judge Chin then made a finding that she had testified, she had a valid fifth because she had testified in front of the grand jury falsely, based on, and the fact that her car was used in the commission of this crime. That was enough of a connection for her to validly assert her fifth. The Commonwealth then went and got immunity for her. She was called in to testify, and at that point in time, claimed that she did not remember a number of things that she had testified to in front of the grand jury. But she had never wavered, not once, about the fact that she was coerced into saying that there was a gun that she saw at that hotel room the night before, or the weekend before.
Maybe that's true, but the judge has to do a preliminary hearing, has to do a voir dire, has to, under 104A, taking into account credibility, by a preponderance of the evidence, make sure that he believes that this witness is feigning. And so maybe it's true that she was threatened, but he obviously came to a different conclusion in deciding that the grand jury minutes could be admissible as prior inconsistent statements substantively because he evidently didn't believe that.
Well, I think you're right, that the judge did make a preliminary finding that she was feigning this inability to recall. But I don't think, given the evidence and given the hearing that the judge had, which is a part of the record in this case, that you can also infer that she was not coerced. So what Judge Chin did is certainly make a finding that she was feigning memory, but there were no specific findings whatsoever that she wasn't coerced. And the only other finding in the record from the time that Judge Chin indicated that she could assert her fifth was this allegation of coercion. And so what the Commonwealth wants the court to do here is infer from the finding that Judge Chin made, because he found she was feigning her lack of memory, that somehow or other that also infers that she was not coerced. And what I'm saying is, on these facts, you need more than that. Because normally you would not have a situation where a witness would come in and claim that she had been coerced into making those statements and have a finding that in fact those statements were false.
Did he have to make that connection though? I mean, when he was hearing her on her Fifth Amendment privilege argument, did he have to actually find that she was not coerced or coerced in order to, did he have to make any findings implicit to the ruling that she was entitled to assert a Fifth Amendment privilege?
He did not, but he actually did. He made a finding on the record that both her car was used, so there was enough of a connection, and that he had determined that she had some exposure because she had testified falsely in front of the grand jury. And that testimony, that false testimony, was her claim that she said that one or both of these defendants had a gun at that hotel room the night before. That's what they were talking about.
The finding that she was coerced into doing it, or she simply lied?
He could make a finding that she lied. He didn't have to make that finding that it was coerced until at the trial, when he was making the determination that she was feigning memory loss. Then I think there has to be some determination, because the law requires some determination that that testimony wasn't coerced.
Can we separate these two for a minute?
Absolutely.
So, there's a Martin hearing.
It is.
Okay, and at the Martin hearing, he decides that she has a Fifth Amendment privilege. Now, that doesn't mean that he credited that she was coerced. He's making a Fifth Amendment finding. Now
agree.
we go to the hearing where he's going to decide whether or not she's feigning, so that the grand jury minutes can be admissible as prior inconsistent statements under oath.
Yes.
Now, what I think you're saying, and tell me if I'm wrong, is that what can't go into the calibration of whether or not there was enough for feigning was that he could disbelieve that she was coerced. That can't go in because it wasn't part of his finding.
Yes.
Okay.
Yes. And what I'm saying is, when the record stands the way it does in this case, that there's been a determination that she has some exposure, and she has a valid fifth because she claimed that she testified falsely in front of the grand jury, that there needs to be more than a mere finding that she's feigning memory loss. You can't infer from these facts that, in fact, there was no coercion, that there should have been a more extensive voir dire on the issue of coercion here, based on the initial Martin hearing, where certainly the issue of coercion was raised by this witness, and there was a finding that she had some exposure as a result of it. Whether you believed it or not, there was an issue that was brought to the court's attention relative to her claim. And this is not a situation, when you look at her trial testimony, that she ever wavered from it. She never said, I didn't say that there was a gun. What she said was, they made me say it. They told me I had to say it. And so if you go through the requirements of when it is that you get to introduce the grand jury minutes, it's usually a situation where a witness is saying, I never said that, or that wasn't me, or it didn't happen in that way.
There were also some I don't remembers.
There were I don't remembers.
But I mean, I don't remembers that on its face that Judge Chin could have found to be incredible.
Well, there has to be some basis in the foundation to make that determination. So certainly she did say on a number of occasions, and I think the Commonwealth has the exact number of occasions, that she didn't recall. But if you look at her testimony, there are a number. Who was in the car? She couldn't recall. Who was there when they dropped off Burger King? She couldn't recall. When did she pick up her sister? She couldn't recall. There are a number of things that she absolutely was saying she couldn't recall, and Judge Chin made a finding that she was feigning memory loss. But the one thing that she never wavered from, the one thing that she always claimed she could recall, is the idea that the reason that she said that the gun, that she saw these guns, were the police officers made her do it. And I think in my brief, or not my brief, somebody else's, I'm arguing for the first time in 27 years, but in any event, we make reference to what she says. And she says, they made me say it, they forced me to say things, they forced me to testify, they forced me to say that Monteiro had a gun.
So would you have a problem if at the hearing on the feigning issue, and the Judge Chin had said, well, as a preliminary question of fact upon which admissibility depends, I do not credit that she was coerced as part of my determination that she's feigning a lack of memory?
I think that's what was necessary. I think the Commonwealth wants it to be inferred, because there's case law that suggests you can infer it. But I'm saying, based on these facts, where you have this Martin hearing, where there's this issue of whether or not she was coerced, you can't just assume, because Judge Chin makes a finding that she's feigning memory loss, that he's also made the finding that she was not coerced. I think when there's evidence in the case that there's coercion, whether you believe it or not, there needs to be more of a voir dire or more evidence from which a judge can make a determination. I'm not saying that Judge Chin could not have found that. Absolutely not. But he needed more from when she raises the claim at the Martin hearing and says that she was coerced, and her trial testimony where she's saying she was coerced, to make a finding to support a finding that she was not coerced.
Does she say at the trial that there was no gun at the hotel? Does she testify contrary to what she testified to at the grand jury?
She did. She said she never saw a gun. They made her say that. That's what she said.
It wasn't just that she, for She said.
She said she didn't remember. They impeached her for a bunch of different things in terms of what she didn't remember. I think that's another issue that the Commonwealth goes sort of overboard in terms of what they get to impeach her with. But the bottom line in this case is that she was very clear, without equivocation whatsoever, that they made her say that there was a gun and that they were threatening her and that she did
In
not.
fact, there was no gun, and she could remember the event, and that there
I don't
was
think
no
anyone specifically said, can you remember if there was a gun or not? There's not that testimony in the record, Your Honor, no. But certainly her unequivocal, unwavering position that the reason that she said that wasn't because she saw a gun, but it was because the police officers said she needed to say that either or both of the defendants had a gun, and that's what she did. And not just said they had a gun, but it had a gun that looked like a police officer's gun, which the Commonwealth inferred then was a Glock, which then somehow matched the weapon that was used to kill the victim in this case. So the suggestion in this case is more than what this court has ever done in terms of determining feigned memory loss. And I'm asking this court, based on these facts, where there is this finding that she is claiming that she was coerced, and it's not a wavering. She's not forgetting that she was coerced. She's not saying, I wasn't coerced. The only evidence in the record is her testimony saying she was coerced. And certainly,
I haven't read the transcripts in full at this point, but is there anything as you go through the transcripts and you look at Judge Chin's findings of whether on this record implicitly in his determination is that he doesn't credit that?
I actually reread the transcripts to try to find that right before the argument over the last week. And I can't find anything in the record from which Judge Chin can make that finding based on the record itself. What we have here is her asserting that she was coerced, Judge Chin, finding that she has a fifth, the Commonwealth coming in and giving her immunity, and then her being required to testify. And there was a situation where she had originally refused to testify, and ultimately they held her overnight. She came in the next day. She purged that contempt by testifying. But even when she was claiming she didn't remember a number of different things that happened that night and how it happened. And she had explanations for that. She had dyslexia. She had a learning disability. And certainly Judge Chin could decide none of that was credible. But in this particular case, the issue of coercion, there's nothing in the record from which he could find that she was wrong or that she wasn't being coerced. There was nothing from which he could make that determination up until the time that she testified. Now, I will tell this court, after she testified, after there was that finding made by the judge that her testimony could come in, then there was testimony from police officers who said they didn't coerce her. But that all happened post the indication that her grand jury testimony could be used against her. What I'm saying is the law has to be more definitive here. If the only evidence that Judge Chin had before him when he made this determination was her unequivocal statement that she had been coerced, and there was nothing else other than that, you can't infer, because he finds that she's feigning memory loss, that she's also feigning this coercion. I don't think that based on this record, there's any determination that you can find that. I think at the end of the trial, you could probably make that finding, because at the end of the trial, there is evidence from other police officers suggesting she wasn't coerced. But what I'm suggesting is in order for Judge Chin to make that determination at the time in which he did, when the grand jury testimony came in, that he needed more than just her unequivocal denial or her unequivocal statement that she had been coerced, because there's nothing from which he can find to the contrary.
What case law are you relying on for us to do this?
Well, that's what I'm saying, Judge. I don't think there.
Is there an extension of the case that you're looking for?
I think, Judge, that the case law in Commonwealth versus Day, where this court has indicated that the foundation to introduce this testimony is that the witness can be sufficiently cross-examined, which in this case, the judge, I think, made that determination that the witness could be cross-examined. But B, in Day, where you say the statement is not coerced in more than a mere corroboration or a denial. And that's where I think this needs to be extended. Because if there's evidence in the record that she was coerced, there has to be a finding that she wasn't. There can't just be an inference based on the fact that we think she's lying about her memory, that she also is lying about being coerced. It's two separate elements. And even in Day, when this court decided Day, they made it two separate elements. You didn't say coercion and then lack of memory. There's A, B, and C in Day, and that B is what I'm concentrated on.
You're Day is way before the first case with feigning a lack of memory. What Day is talking about in that 801D 1A finding for a prior inconsistent statement under oath, and back then it was only for an identification,
Right.
as you remember.
And then there's Clements and all of those cases,
But
yes.
back then, so all that meant at that point in time was the statement in the grand jury couldn't have been a coerced statement of identification because it was limited to identification. Now we're in a whole, and so that's the law there. Now what you're saying, and you might be right, but now you're saying something different. You're saying that in order to say that there's been a feigning of a lack of memory, you got to make a finding that the person wasn't coerced.
No, Judge, not, if I could answer that, I know my time is up, but may I answer that question? Here is what I'm saying, is it may not always be necessary to make that individual finding, but on these facts, in this record, where there's only evidence that she's saying she was coerced and no contrary evidence that she was not, there needs to be a specific finding that she was not coerced. That's what I'm saying.
Okay.
So I'm a little bit confused because I'm not, there are two things going on, and I'm not sure if you mean both or one. Are you saying that a judge must make findings as to each of the Day elements before admitting it and must make them on the record, and we can't infer that a judge made those findings from his or her admission? Or are you saying that on the record before the judge, that no reasonable judge could have made the finding of no coercion because there was not evidence addressing that issue?
That's what I'm saying, Judge, the second. I'm not saying that there aren't occasions where judges can make determination of feigning memory without going through every single issue that's raised throughout the cases. I'm saying when all of the evidence you have that's before you at the time that you're making this decision is the declarant's statement that she was coerced, without ever hearing from anyone to say that that's not true, if you disbelieve her, if that's what you're coming to by saying she's feigning a memory loss, you need to have some factual basis to do that, and you need to put that on the record. It can't be inferred when there's contrary evidence and no other evidence to suggest it wasn't coerced.
Except that if he disbelieved her generally.
If he disbelieved her generally, Judge, in terms of whether or not she was feigning a memory loss and or being coerced, I still think that under the facts of this case, where the only evidence is that she was coerced and there was nothing specific to suggest she wasn't, that there needed to be a specific finding, not in every case, but
here
in this case.
I guess I'm confused a little bit too. Is it that you're saying that there wasn't an evidentiary basis for the judge to make a finding that she wasn't coerced? Or is it that the judge simply didn't find, I don't believe her, when she claims she was coerced?
I think the judge didn't make any finding that he didn't believe her, and I think that he couldn't have made that finding based on the record without something contrary to what was going on.
And, you know, her demeanor, her whatever, I mean, you know, couldn't he assess her credibility simply by virtue of what he'd heard?
He absolutely could assess her credibility, Judge, in determining whether or not she was feigning memory loss, but she wasn't feigning memory loss about this issue.
I know, but I'm just saying, why is that a different weighing when you're assessing someone's credibility? I mean, isn't he free to say, I heard her before when she said this in connection with the Fifth Amendment issue. I hear what she's saying now. I just don't believe this woman.
Right. And if he makes that statement that he doesn't believe her, I think he needs to make a statement, doesn't believe that she doesn't have a memory and doesn't believe that she was coerced.
Oh, but he could. So I guess that's the question. I mean, so it sort of is not the same thing as he didn't have any basis that no reasonable judge could have made that finding.
Well, I think when it's discretionary, you can always find a reasonable basis to do whatever you need to do. So I'm not suggesting that, but I'm saying based on these facts, there needed to be more in the record to suggest that she was not coerced. And the only facts the judge had available to him are the facts on which he determined that she had already had a valid fifth based on her grand jury testimony, and then allowed that grand jury testimony in on a finding that she was feigning memory loss. But the memory loss that he made that determination on, Your Honor, and I think this is important, didn't relate to the issue that she was coerced. She never wavered from that. She never feigned memory loss as to that.
But
That's the problem.
didn't the Martin hearing lay the foundation for what the judge ultimately concluded that the grand jury testimony should come in? I mean, he's making a determination that she knows something, she's done something, that could implicate her in this case. So to find, to get to where you are, I guess he would have to say that he made a mistake in saying that she had a Fifth Amendment privilege after that hearing. Right?
No,
No?
because I think the fifth is different. The fifth is a link in the chain.
No, I understand, but I'm just trying to say, maybe I'm wrong about this, but it just seemed to me that he has to go back on what he said when he granted her Fifth Amendment privilege.
Exactly.
He's finding that she's not being truthful, right?
And if she's not being truthful about that, then how did she get a fifth as a result of that?
But that's not true. I mean,
But,
for Martin hearing, all you need to find is that
There's exposure.
there's exposure.
Right.
And the jury could, I mean, if you were to prosecute her for perjury, a jury could find that I don't credit her claim that she was coerced. I think she just lied, and therefore she'd be exposing herself by later testifying in a manner that may be contrary.
Absolutely, Judge. But in this case, what I'm saying is, because the record was so clear and because she never wavered on the coercion, there needed to be a finding that that was false, that the judge didn't believe that or didn't credit that, and that's how he got to the issue of the substantive use of the grand jury minutes. I know I'm way beyond my time.
Infer that, right? You're saying we can't infer that.
You can't on these facts. I'm not saying you can never infer it, Your Honor. What I'm saying is, based on these facts that were before Judge Chin at the time, that he should not have been able to infer it, that he should be, this is a murder case. There should be a clear record. And when the record is that she had been coerced, if Judge Chin reasonably believed that she wasn't coerced, he should have said it. There should have been some finding on the record from which you could review whether or not that was reasonable. But we don't have a finding. We just have an inference based on the fact that he said she was feigning memory loss, that he also meant she was feigning this, or she wasn't credible when she determined that she was being coerced.
Well, the prosecutor's just going to say, well, look at the transcripts before that and how incredible it is that she wouldn't remember this, and so therefore...
But it's not the memory, Judge. That's the problem with this one issue, is it's not about her feigning memory loss on this issue. She never did. That's what makes it different. She's not saying, I don't remember there being a gun. She's saying, they told me to say there was a gun.
I know, but this is the response. Whether it's accurate or not, the response is this. When I look at this whole record and I listen to this testimony and the things that she's saying she doesn't believe, that she just testified to, that aren't the type of things you could possibly forget about what happened on your birthday and everything else, then I just don't believe that she was coerced into saying this about the gun. I don't believe it. That's what the argument's going to be. Whether that ends up being a good argument or not, that's the argument.
It is, Judge. It's whether or not, based on these facts, the judge could make that finding. And that's really what it comes down to, is are you going to require a trial judge in a situation where there's a claim of coercion to specifically put on the record that there's a finding that there's no coercion, so that then you can review that for reasonableness? Because right now we're all guessing, we're all assuming, and we're all inferring. And my client's doing a life sentence, and I think that this court should require more.
Okay, thank you.
Thank you.
Mr. Naiman, good morning.
Good morning. May it please the court, Mr. Chief Justice, Justice of the Court. My name is Steve Nyman. I represent Isaiah Monteiro. I apologize that some of my argument, if not actually all of my argument, is going to be a little bit repetitive, but slightly different from what Ms. Capiccio argued relative to Mr. DePina. I do, however, want to focus on the substantive use of the grand jury minutes relative to my client, but in two particular aspects. One being the gun itself, the second one being the fight, or the attribution of motive, so to speak, to my client. First of all, the court should note that and I think I put it on page 28 of my brief, the jury actually came back with a question during the deliberation and asked, was it before or after Ms. De Silva's grand jury testimony that she was granted immunity? It's a pretty telling question, because obviously they, as counsel just referenced, were heavily focused on the credibility of Ms. De Silva and her testimony.
Now,
It's
her
also,
testimony was crucial as to what point?
well, as to many points. First of all, assigning a motive to my client and also putting a gun in my client's hand. If you notice, the verdicts came back relative to the shooting, all not guiltings as to Mr. Monteiro, guilty as to the murder, so it's obviously on a joint venture theory, guilty as to possession of the firearm, again, obviously under a joint venture theory because no one puts any observation of a gun in the car or in my client's possession prior to the shooting. The possession of a gun comes a few days before over at the hotel, and that's again through Ms. De Silva's testimony, as it only comes in before the grand jury. What's also interesting, just to backtrack a little bit, or maybe perhaps troubling, is that you find a Fifth, or the judge in this case finds a Fifth Amendment privilege, arguably in part because of perjury before the grand jury, yet permits the substantive use of perjured testimony against my client, and ultimately, in my opinion, has the devastating effect of a conviction in this particular case.
But the judge didn't find it to be perjured.
Well, that was...
The judge simply recognized that if she were to testify differently, she'd be at risk of being charged with perjury.
With knowledge, obviously, based on this hearing, that she's going to testify differently because she's disavowing that this ever happened. Rather, what she's saying is she was forced to say it. And that's the same exact thing. She's saying, what I did, I was forced to testify falsely before the grand jury. So prospectively, that's perjury, but the judge is saying, I don't care, I'm going to let the Commonwealth use it. And more troubling is the fact that the Commonwealth would use what they would believe to be perjured testimony to come in substantively against defendants in a murder case. It's troubling. It's extremely troubling. The other thing that I want to point out to the court is the use of this gun relative to my client, period, is troubling. So you have the identification of the gun as being, by Ms. De Silva before the grand jury, as being a black firearm, and you have Mr. Byrd testifying at trial that the firearm that he saw the shooter using was a brown firearm. And the distinction isn't subtle, it's significant. I also want to point out to this court that the prosecutor, relative to use of that evidence of, use of the evidence that Mr. DePina was arrested with a firearm 3 days later, opted not to use it. And what the prosecutor said, and this is January 17th, 2014, page 34 and 35, I'm not trying to put in the fact that he, Mr. DePina, was arrested for possession of a firearm. I clearly think that that would be overly prejudicial, as that gun was not determined, was determined not to be related to the actual shooting. Nor was there ever a determination that the gun that Ms. De Silva supposedly saw was used in the actual shooting.
But I gather from the shells, it was a .40 caliber, correct?
Right.
40 millimeter.
40 caliber, I think. I think that's what she had.
Okay, and I gather that her description of the firearm was consistent with it being a semi-automatic.
Well, she pointed to apparently pointed to Detective Clark's gun and said, just like that one, and he identified that as being a 40 millimeter. And then
So it was consistent with the weapon that was used. Perhaps you can't show that it was the weapon that was used, but it was consistent. I don't know what the firearm was for the, but if it had been a handgun inconsistent, I understand that the prosecutor would appropriately take that position, but this one appeared to be consistent.
Well, I think it's certainly a stretch. It looked like that gun there, and then, okay, well, my gun is a .40 caliber, and that's the same type of ammunition that happened to be filled. It looked like that. A layperson who was, by the way, claiming that she was coerced and disavowing that this is what she said, but even if you get beyond that, it looked like that, and therefore, so we're going to make this leap and say that that must have been the gun, and that's the only way that the jury can find my client guilty of murder or possession of a firearm in this particular case, because they find him not guilty of the actual shooting. So he doesn't get of the other shootings. So he's not found as a joint venture or relative to those shootings, so it must be because that firearm was used in the murder and he had it before that we're going to say that he is guilty as a joint venture.
You also have the attribution of motive with regard to this particular victim,
Which
which
was a
I
little
know
bit
is your-
confusing, but yes. I mean, it was, so it's hard to sort of figure from again, from her grand jury testimony, but who jumped who? I think the ultimate reading is, but it's not worded this way, was that my client was jumped by the victim and the victim's brother prior to this, but that's not really the wording of it. And again, for those reasons, that shouldn't have come in.
What about, well, go back, if we could, to the gun for a moment, please. What about all the cases that stand for the proposition with much longer times between seeing the gun and the shooting, that is evidence available to show the means to commit the crime? There's so many cases on that point.
Right, which would be the same, you're right, which would be the same thing relative to Mr. DePina and finding the gun on him 3 days subsequent to the murder when he was actually arrested. But then again, embracing the prosecutor's statement, I'm not trying to put the fact in that he was arrested for possession of a firearm. I clearly think that that would be overly prejudicial. That's his belief. It would be overly prejudicial as that gun was determined not to be related to the actual shooting, and nor was this gun. So I understand what you're saying, but the prosecutor was troubled by it, would not use the gun against Mr. DePina, should have been equally as troubled by that proposition of using a gun, particularly under the circumstances that I prefaced my argument with, that being that you believe it to be perjured testimony, or know it to be perjured testimony, you want to offer substantively against the person and just make this leap that, yep, he had a gun a couple days earlier, kind of similar, pointed to the officer's gun, according to the officer, and said, look like that one, and oh, by the way, that's a .40 caliber, and we found 15 plus shell casings at the scene. It's really, really troubling. It really is in this particular case. So that's really the focus of my argument. I think the rest of the issues before the court are self-explanatory, unless there is anything that the court has a specific
I didn't
question
really
on.
see, I guess I just have one question. Can you explain your argument, how there would be mutually antagonistic defenses, the Moran argument in this case for severance?
Well, yeah, so I think, and you understand from trying cases that you sort of have to pick a different strategy sometimes when you're saddled with another defendant sitting right next to you. It's not, and you might have to restrain yourself as to some of the things you can and will say in a particular case. And there's countless strategic reasons for that. In this particular case, to actually stand up there and point the finger at your co-defendant is probably the most antagonistic of all defenses. And that's really what you want to be able to do in a case like this without risking severe prejudice to yourself because the co-defendant is there by doing it that way. And that's, I think, exactly what Mr. Fogarty was getting at when he moved for severance. I think Mr. Sheketov actually agreed with him, and he in particular argued that Moran was not discretionary, but he felt that Moran was an obligation of the court if you find the mutual antagonistic defenses. Again, getting to the gun that was found 3 days later on Mr. DePina, that's the first thing as a defense attorney representing Mr. Monteiro alone that you would reference. So number one, he didn't get out of the car.
But I don't know what your proffer is as to why it was mutually antagonistic. Your argument that it's a strategic problem has been said by us many times to not be enough. What is the mutually I mean, I wasn't sure. In closing, what did he argue in closing?
That one person did it, the other person didn't, and actually, Mr. Monteiro, as related by Mr. DeSanto and one of the other witnesses, was surprised when he heard the gunshot. One of the witnesses said that he actually had ducked. He and Mr. DeSanto had ducked together when they heard the gunshot, and Mr. DeSanto said that Mr. Monteiro was surprised when he heard the gunshot. Certainly not indicative of somebody who was driving over the north side of Brockton to participate in some sort of a revenge killing.
So why is why is that antagonistic? The argument I gather is, I'm driving a car, DePina leaves the car, comes back. I didn't know that he was going to shoot somebody. Why is that antagonistic to DePina's defense, where he doesn't testify? He's just is relying upon the inferences of the evidence that's already in.
Well, well, I'm referring to the inferences. And so I'm referring to the inferences, and also what has to be, well, what strategically was omitted in terms of arguing relative to the inferences. And I think it's mutually, obviously it's mutual, it's antagonistic on both sides. Maybe I'm not articulating it well, but I think it was pretty clear from the evidence in this case. The only other thing that I want to point out really quickly to the court, you probably already had a chance to read it, it's on page 38 of my brief, is the implicit vouching for Mr. DeSanto in this case, having him testify during direct examination that the reason he didn't come forward till later was because he was in fear for his life. That's not proper that's not proper period, but it's certainly not proper in direct examination. Any kind of delayed response. I'm in fear for my life. He's imputing a violent nature and tendencies to people who enjoy a presumption of innocence at that particular time, one that's not supported. Certainly, he goes through a litany of reasons why his life was in danger and how dangerous it is to testify. That might perhaps be something that's more appropriate on redirect examination if it's opened up by the defense in its line of questioning to the witness. It was highly inappropriate here. It suggests to the jury this guy is telling the truth, and the reason he delayed in coming forward and saying anything was because he was in fear of his life, because these are bad guys. They drive around the north side of Brockton with guns and shoot people.
Well, what was the context? Was he being impeached by the prosecutor, for instance, at that point in time?
I guess if you want to call it impeachment, but I think it was more establishing credibility. I don't really look at it as impeachment. It's like, why did you take so long to come in here?
No, I understand that's not impeachment, that's rehabilitation. When the prosecutor asks, why you have all these inconsistent statements, why did you not say anything for all this period of time? And then you ask the question, and then, is there a reason for that? Yes, I was scared. That's rehabilitation. I take your point as a very important point, that should wait for redirect. That's a very reasonable point. I'm just asking, because I haven't read the transcript of this particular area, was something going on direct where the prosecutor was in a position that the prosecutor was actually impeaching the witness or trying to explain why there was such a delay in coming forward, or something about the credibility that needed to be rehabilitated?
No, I think it was just an explanation that the prosecutor was trying to offer through the witness that is tantamount to vouching. It's saying, and of course the reason you didn't come forward was because you were scared, because there's a legitimate fear of retaliation.
Was that Monteiro had not, I'm sorry, that DeSantos had not come forward, or that DeSanto had affirmatively lied the first time they spoke with him?
Well, there was both involved.
Okay, so the first statement he made said basically, I know nothing.
Correct.
So what's a prosecutor to do? He puts DeSanto on the stand. The first statement is, I know nothing, and then he later is going to say, well, actually, I do know something.
Well, I mean,
the prosecutor's supposed to then
there's other reasons.
not elicit the first and wait for and conceal that from the jury and let the defense attorney bring it in? Or can't the prosecutor bring it up and address it and essentially said, well, how come you didn't tell us that the first time?
There's other reasons that don't amount to vouching. One of the reasons is I live in this neighborhood. I just didn't want to get involved. I mean, that's the easiest one. Not, I'm in fear.
But that wasn't true. That wasn't the reason.
Well, it certainly was part of the reason that they don't want to get involved. They're friends. They're cousins.
Okay, thank you. Ms. Anderson, good morning.
Good morning, Your Honors. Good morning. Audrey Anderson for the Commonwealth, if it pleases the court. First, I'd like to disagree with my sister that the Commonwealth has not conceded that it absolutely needed Lisa Da Silva, that she was basically the most important witness. my brother and sister seem to forget Kevin DeSanto. Lisa De Silva was not a recipient witness. She wasn't there at all. There was no testimony that she knew about the crime. Kevin DeSanto was there, and he gave testimony of what happened. He testified that they rode around town. He, his cousin, Mr. Monteiro, and Mr. DePina, the friend, rode around town smoking marijuana. He noticed that they were on the wrong side of town, the north side of town. And he said to them, "What are we doing over this side of town? Just relax, just relax." They were from the south side. They had a beef with the north side of town. He was like, "I don't like being here." They went around, driving around, and Mr. Monteiro notices a group of people. Just there they are. Mr. DeSanto gets out of the vehicle, leaves. Mr. DePina. Mr. DeSanto testifies maybe 15 seconds later. He hears bang, 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 bang. Mr. DePina runs back to the car, comes back and says, "I think I got him." Mr. Monteiro says, Monteiro doesn't ask, who did you get? He says, "All right." And Mr. DePina gets in the car, and he says, "We got to get the hell out of here. Go, go, go." Mr. DeSantos, who's Mr. Monteiro's cousin, who they grew up together, they had basically lived together in the same home, said, "What is going on?" He said it several times. He was told by his cousin, Mr. Monteiro, shit popped off, which means someone was shot. He kept asking, "What is going on? What is going on?" He was told to just be quiet and stop acting like a pussy. And my point just there is the Commonwealth had very, very strong evidence without Ms. De Silva. But as far as the feigned memory, the defendant's dissatisfaction is based on the judge's findings of evidence. The defendant's preference was that the judge make different findings, but that doesn't make the judge's findings clearly erroneous.
Did the judge make a finding as to coercion? Did he need to?
He didn't need to make a specific, explicit finding. He looked at all of the evidence, and taking Day into consideration, the judge was perfectly aware of Day. He could find, and we can infer, that he felt that she was not coerced. He did make other findings. He did not believe her. There was the Martin hearing, then there was an extensive, basically 2 voir dires of Mr. Silva, where she's just saying, "I don't know. The reason I'm saying this," she told her attorney, "the reason I'm saying this is because I just don't want to be involved in this." The judge found that she had some fear.
Was one of them a contempt hearing?
Pardon me?
Did she refuse to testify?
Yes, she did. After she had received immunity, she did not testify. The judge was asking her questions. Judge said that she was playing with the court. She told the judge she was not playing with the court, and she got up. The judge told her to please sit down. She ran out and left the courtroom. The judge held her into court. She was brought in the next day. She had a child. The judge decided not to put her in the house of correction. Then she decided to testify.
But she was held overnight one day, one night.
She was held overnight. And she said, "I don't care, I'll go to jail." Are there any specific questions that Your Honors would have?
So as a result of these hearings, are you saying that the judge had enough information to know that she was not someone he credited? Is that what you're saying?
Basically, yes, because the judge made findings that from observing her.
That she was feigning her memory, so that he thinks that she was lying in that regard. Are you saying the fact that she was lying in that regard means that he also believed that she was lying about having been coerced?
Yes, There was also testimony from an officer. The judge found that she feigned memory in transcript number 5. I really can't say 100% when the officer testified. She said that, oh, I don't remember certain things, but if I did say it, the officer told me. The red-headed officer who played the bad cop told me. The officers that interviewed her were an officer from Brockton and an officer from the state police. The red-headed officer drove her to the grand jury hearing. He had never interviewed her. He did not, and he testified, he did not tell her to
Ms.
say it.
Capiccio told us that that all came in after the determination of feigning.
What I'm saying is, I'm really not sure. I just can't remember which transcript that came in. But I know her feigned memory wasn't decided by the judge until the 4th day of trial.
Could Judge Chin?
Yes, Chin.
Could Judge Chin find in his own mind, well, I think that she was coerced, and she didn't really believe, it wasn't true what she was saying in the grand jury. I think she was actually coerced. And then be able to make a finding that where he says, well, I think she's feigning a lack of memory, so I'll let in that testimony in the grand jury that I don't think was true because I think she was coerced. That would be, there's no logic to that type of determination.
I think I'm kind of lost with that question.
So
because
here it is. How could Judge Chin think that the grand jury testimony was coerced? And
he didn't.
I understand.
Oh, okay.
I understand. I'm just trying to understand how the logic could possibly be, as the appellants are saying, at the feigning point. How could he say, I think she was lying in the grand jury because she was coerced, but now I think she's feigning a lack of memory, so I think I will allow in that coerced grand jury testimony to impeach the testimony at trial. That makes no sense.
That makes no sense. And what would he base it on when he's listened to her testimony, where she's saying, I don't know, I don't remember, I don't recall. And her grand jury testimony was so clear and so concise. Judge Chin would not or could not go back and say that, I find that her testimony, now that it's okay, let it in. I don't understand that.
Do we have the record of the Martin hearing?
Part of it.
The part that was in the courtroom?
That was, part of it the judge gave to the both attorneys, and there's some references in the transcript.
Okay, and do we understand from what is in the record that she would have testified that she saw no gun? If she were forced to testify, she would say, I didn't see a gun in the hotel room.
If she was forced to testify?
Can we infer that at the Martin hearing, she told the judge, in the grand jury, they forced me to say that there was a gun, but I didn't see a gun, and if I were obliged to testify, I would say that I did not see a gun.
I think you could infer that.
Okay. And therefore, there would be, one of those statements would be false. And a judge could say, well, you are now, if you say that, you're putting yourself at risk of a perjury prosecution, correct?
Yes.
And although you may make a defense that says, no, I did not perjure myself when I said subsequently that I did not see a gun, because the first time I was coerced into saying it, a judge could say, well, a jury might not believe you. And that's all that a judge need to find. The judge does not need to say, I don't believe you. It's just that you're at risk of, that you're incriminating yourself, putting yourself at risk by your testimony, and therefore you have a valid Fifth Amendment right.
And he didn't say, I don't believe you. He just told her that, he just said, I believe that she has a
A valid Fifth Amendment right, right. So, I mean, I don't think we can infer that much from the Martin hearing. in terms of whether the judge believed or disbelieved her claim of coercion. All you can infer is that the judge recognized appropriately that she would be putting herself at risk if she were forced to testify without immunity.
Yes, it's the voir dire where after the voir dire is where the judge made his findings, where she got on the stand, and she was basically, she would answer the defendant's questions or anything she thought that could help the defendant. But anything else, I think 50 times she told the Commonwealth, I don't recall or I don't remember, and she only did that twice for the defendant.
Isn't this whole discussion, though, proving that the appellants are correct, that there should be precise findings about this? So what's going on when it's a dramatic thing to have happen. The witness is on the witness stand, and they're testifying to the jury under oath that X happened, or that they don't remember what happened. And we're allowing in previous testimony that wasn't cross-examined in the grand jury without defense counsel there, because the judge is finding that that testimony at trial is being feigned, and what was said in the grand jury was true. Shouldn't, instead of us engaging in the questions that Chief Justice Gans just asked, for instance, all the questions that we've been asking the appellants, shouldn't the judge have to make thorough findings under 104A before you allow in that type of testimony?
Well, I believe with the state of the law, where is it now? It is now that he doesn't have to. That he doesn't have to just specifically make each and every finding under day. I think that the judge can make that determination from the voir dires. That's the way I read the law now.
Sure, but we're trying to understand what was going on in Judge Chin's mind about this statement that the witness made about that her testimony was coerced as it related to the gun, and going through all these questions and trying to figure out implicitly in the record. Doesn't it make sense that if you're going to make a preliminary finding of fact upon which admissibility depends, 104A, that the findings have to be pretty thorough so that we can understand it?
Your Honor, from my reading of the transcript, I'm saying that the judge did enough, and the judge was not obliged to believe her self-serving statements. I really cannot say much more about that because the state of the law is what it is. Are there any other further questions, or can I clarify anything for Your Honors? I would just like to say that this was a horrendous murder planned by two young men who went out and intentionally looking for these individuals. They came into a neighborhood where people are out in the street doing their gardening, doing their cleaning, and with a .40 caliber weapon, Defendant DePina let off at least between 11 and 15 rounds. There were at least 5 people standing on the steps. It's just by the grace of God that only the defendant was hit. On the other side of the street, another woman who had just let her elderly mother off, her car was hit by bullets. They obviously did not care who was hurt or who was killed that day by their actions. And I would ask that the court affirm the convictions of the defendants.
Okay, thank you.
Thank you.
All right. Hear ye,